designation on it, yes or no? If it has a beneficiary designation on it, you modify the beneficiary designation. If it doesn't have a beneficiary designation on it, you got to change the name on the ownership. Okay? First of all, what is a beneficiary designation? A beneficiary designation is a contract between you and a third-party custodian, life insurance company, 401k custodian, IRA, annuity company, whatever. And the contract says that when I die, they pay the money to whoever I listed on the beneficiary form to receive it. Okay? Well, if there's a beneficiary named when I die, do we care who owns it when I die? No, the only thing that's relevant when I die is who gets it. So on all these assets, 401ks, IRAs, annuities, life insurance, credit union accounts, blah, 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 you don't have to change the ownership. All you got to do is play with one simple form that takes 5 minutes to fill out. You can even do it online now. A lot of the companies have things where you can change beneficiaries online. The big thing is just authenticating who you are. And so you have to print it out, and you got to put it in a number 10 envelope, and you got to get your priest to swear by it and put it in the mail, and then everything's wonderful. But in the big scheme of things, that's about as difficult as it gets. Okay? So, what do you do with beneficiaries? Okay? Well, normally there's two: primary, contingent. Primary beneficiary means if I die, who gets it? Bingo. Contingent means, and you'll also hear the term alternate or secondary beneficiary, means the exact same thing. That means if she's dead, who gets it? She does. Okay? So what do you do when you have a trust? The short answer is keep the spouse as the primary beneficiary for everything. I get arguments from lawyers about this all the time, but just do it. Okay? Because it's simple. Spouse gets everything, and if something happens to the spouse, make the trust the secondary beneficiary, the contingent beneficiary. The idea is while we're alive, we keep everything together, and if something happens to both of us, then everything defaults to the trust. It's the easiest way to do it. There are some problems with 401ks and IRAs if you send it to the trust rather than to the kids, blah, blah, blah. But hopefully they're going to fix all that stuff in the next couple of years. But I would just assume you send everything to the trust, because people say, well, if I send it to my kid and my kid's 20 years old, he can blow all the money. I'm like, yeah, he can. Because the idea is if everything defaults to the trust, then the trustee is taking care of the money, and that's why you did the whole thing in the first place. Right? So what about stuff that doesn't have a beneficiary designation? Real estate, investment accounts, bank accounts, personal property. Got to change the name on the ownership. With real estate, you do deeds. I do those for my clients all the time. Okay? What you got to watch out for is if you refinance. Why? Because the banks don't like loaning money to your trust. They want to loan it to you. So they make you do a deed reversing this. So you as trustees hereby grants to you as joint tenants. They record that. Then they record their new mortgage, otherwise known as a deed of trust in California. Then you would think they would be kind enough to do another deed just like this, putting it back in. They don't. I've gone to clients that I did trust for 20 years ago to do a review, and I asked a stupid question. Is your house still in your trust? Well, of course it is. Why wouldn't it be? Well, did you refinance? Oh yeah, like 4 times. The first time it was like 6, and then it was 5, and this last time it was 3 1/4 and no closing costs. And then I go online and I look up and I see, sure enough, there was a deed taking it out. And there wasn't one going back in, and their faces just go white. Because what happens when you're at escrow? You're signing like 72 documents in 45 minutes, and sign here. I just did one. I'm a trustee of a trust for one of my clients that passed away. And I'm selling a house, and I'm like, I don't even understand these disclosures, and I'm a lawyer. And you're sitting there, oh, it's so easy, just here, stick that in front of you and sign, oh, thank you very much, next document. But that's what happens. So I always tell my clients, if you refinance, just call me, I'll walk you through it, okay? If you're not my client and you want to call me, go ahead, call me, okay? All right, now, investment accounts, mutual fund brokerage, internet accounts. What usually happens is you have to go online and open a trust account. They have individual accounts, joint accounts, and trust account. You're going to open a trust account, and they're going to say, what kind of trust? Revocable. Ding, check the box. Then you fill all the information in, and that's it. And then what you do is you sign an account transfer form. What the account transfer form does is it moves the money from the joint account over into the trust account. I like to put it like this. You're moving the money from one warehouse to the other warehouse. Because there's no capital gains involved, there's no taxes. All you're doing is changing it from one warehouse to the other. You're having it from the old joint and you're putting it in the trust. It's that simple. On bank accounts, you're just gonna change the name on the account. Do you have to reorder checks? No. I don't care what the check says. Most people, oh, you get a check from, oh, a trust, oh, you must have money. So I don't care if your checks just say Joe and Mary on them, or Joe or whatever, I don't care. Okay, it means nothing. The only thing that matters to me is who's on the bank statement. That's it. Okay? Now, last question. Do you need a will if you have a trust? The answer is yes. It's what's called a pour-over will. If nothing's going to probate, you don't really need the will for anything, right? Well, the main purpose of a will when you have a trust is that's a document that nominates the guardians for the kids. Some attorneys want you to nominate guardians in the trust, and that is just like felony stupid. Because the document that nominates the guardians has to get filed in the court, because that's what the judge reviews to make his legal determination on guardianship. So if you name it in your trust, you have to file your trust with the court, which means you just took your private family trust and turned it into public record. So you have a very simple pour-over will. I call it a skeleton trust. It basically says, Martine, I name you as executor. Jennifer, I name you as guardian. And third, I leave everything to my trust if I screwed up and didn't put something in it like I was supposed to. Okay, it's a pour-over will. Okay, how are we doing? Everybody okay for about another 5 minutes?
Yeah. Yeah.
Okay. When I first started, I had a really wonderful couple, and they had 3 kids. They had 2 lovely girls and 1 son, as I call him, Charles Manson Jr. He was doing 10, I'm serious, he was doing 10 plus in state prison for armed robbery and all kinds of stuff. And mom and dad were like not amused at all. So they left him 10 grand and they left everything else for the girls. Okay? And then as I found out, a couple of years later, they bought a condo up in Mammoth because they really liked it up there. They didn't put it in their trust, they just put it in joint tenancy and they forgot about it. Okay? Then mom died, then dad died, the girls came to me in a panic. They go, it's not in the trust, it's my brother getting a third. And I said, can I see your mom's will? It's the same will I did. Still good. Never failed. What does the will say? It says, I, mom, leave everything to my trust. So we did a probate up in the county where Mammoth is. Final result was the judge signed a court order that said the trust owns it. So that's why you do it. It's a pour-over will. It's kind of like a fail-safe. So on trust funding, your trust is either going to own it, be the beneficiary of it, or if you screw up, it'll get it via the will. But what's the problem with using the will? It's going to probate, which is what you're trying to avoid in the first place. So, last thing, what are you going to do about lawyers? You can go to the discount lawyers and good luck. Okay? You can go to the big firms downtown and they're going to hit you for big money. Okay? They just are. Solos like me are $1,500 to $2 grand. I run specials all the time. And I don't know, I think a reasonable day's wage for a good job is worth it. You can do it yourself, but the problem with doing your own estate planning is you're not going to know if you screwed it up. Your family's got to find out. So some people do their own bankruptcy, some people do their own divorce, and what will happen is the court will say you screwed this, and this up, fix it. You don't have that opportunity with estate planning because you're gone. So I think if there's really one time where you want competent representation, it's in estate planning. Okay? Malpractice insurance. Most people don't realize this. In California, I know it's a really consumer-oriented state, but there is no requirement that attorneys have malpractice insurance as of right now. So if you hire a lawyer and the lawyer screws up, if that lawyer didn't carry malpractice insurance, no malpractice attorney is going to take your case to sue that guy. Okay? And I want you to understand, I haven't had any claims in 21 years, and my malpractice insurance is $5,000 a year. And I've heard my buddies go through this. Family vacation to Hawaii, malpractice insurance. What do? Okay, I pay my malpractice premium because I don't want to get hit. Okay, and it's tough. I mean, writing that check is a bitch. Okay, it's big money. People say, why do lawyers charge a lot? Well, that's what our insurance is. So you got to look at that. So what I always tell people is I don't care if you're hiring the greatest lawyer on the face of the earth. Ask them what the name of their malpractice carrier is. You notice I didn't say, do you have malpractice insurance? Why? Because it's an easy lie. Ask them, what is the name of your malpractice carrier? Mine's Arch. Okay? Because if they can't tell you what it is, maybe they don't have it. Okay? And far be it from a lawyer to ever lie. It never happens. Okay? Experience and technical knowledge. Okay? I can handle a civil litigation case. It doesn't mean I want to do it. Okay, and what happens is I might run into trouble if I did it, so I don't do it. So make sure that when you're hiring a lawyer, make sure that they're knowledgeable in the area of law that you're hiring. A lot of people say, well, that you only want somebody, that's all they do. I don't see how you can really make it in this society if you're not practicing in a couple different areas of law. And I also wonder about your competency. I see bankruptcy attorneys, all they do is bankruptcy. I'm like, I can do bankruptcy in my sleep. Give me something, you know, more technical or something really challenging, because that's, you know, I just think that's how you really can tell a good lawyer, if he can help you with pretty much every problem. It doesn't mean I'm going to represent you, but if I can't talk coherently about a particular area of law, then it makes me wonder. So, in any event, as part of the handouts, everybody got a questionnaire. If anybody wants a free consultation, just check the box and get the forms back to Jennifer, and I'll be glad to meet with you. And that goes for people up in Orange County. I travel up there too. And the only thing I ever ask, I'm glad to do all kinds of free stuff for you. You can email me, call me, whatever. The only thing I ever ask is that if you know people that can use my services, just please refer me. That's all I ever ask. Okay? So thank you very much, and hope you guys enjoyed the class.